Do you want to hang out sometime?
Well, that man has creepy vibes. Yes, hello, we need help right now. We're in the park near the main entrance. Please hurry. Hands up. Get on the ground now.
Do not move.
That man with black shirt and black hat creeped me out. I feel terrified.
We know who he is. We will arrest him under H 3055.
What are you in here for?
Bothering women. Some bill called H 3055. I am here for the same thing and did not know anything about it. I am here for the same thing. I did not know anything about it. Cops don't tell you new laws. I was making over $1,000 a week as a car salesman. I am a millionaire. I am homeless. How did you get that job? I got the job at the bar. I don't do drugs. I made the beer app. You are a hero.
This court is now in session. We are here to finalize the sentencing. Matt, you are sentenced to 15 years. You knew what you were doing and you don't drink. If you continue bothering women, you will be here a lot longer. Get him out of here.
South Carolina. This state-level bill might be the one you're after. It aims to toughen laws regarding harassment and stalking. The pattern change. It proposes to redefine a pattern of harassment. Currently, a pattern usually involves multiple acts against one person. This bill would change it so that if a person commits one act against one victim and another act against a different victim, it still counts as a pattern of behavior. Removal of the 10-year rule. It seeks to remove the current 10-year limit on prior offenses. This means a decades-old conviction for stalking or harassment could still be used to enhance the charges and penalties for a new offense. Current status. As of early 2026, the bill is residing in the House Judiciary Committee. It was introduced in January 2025 and has seen several sponsors added, including Representatives Crawford and Guest, throughout 2025. Under current law, a pattern typically implies multiple acts against the same individual. H. 3055 changes this definition so that multiple victims count. A pattern would now include instances where a person commits one act against one victim and a second act against a different victim. The goal: this allows prosecutors to establish a pattern of behavior based on a defendant's overall conduct, rather than treating each victim as an isolated case currently. Prior convictions for harassment or stalking only count toward increasing the severity of a new charge if they occurred within the last 10 years. The change, H. 3055 proposes to remove the 10-year restriction. The impact: any prior conviction, regardless of how old it is, would be used to enhance the penalties for a new offense, e.g., turning a misdemeanor into a felony. In South Carolina, being told to leave can happen in two ways. One is a simple verbal warning that carries immediate legal weight, and the other involves formal paperwork. Under SC Code Section 16-11-600, there is no requirement for a piece of paper for a notice to be legally binding. The pattern trap, H. 3055 influence. This is where the new law, H. 3055, becomes dangerous for a defendant. Building a file. Even if the police don't arrest you that day because you didn't technically break a law, you were just creeping her out. That report stays in the system. The second complaint. If a different woman calls the police a month later for a similar reason, the responding officer will see the first report in their computer. The pattern trigger. Under H. 3055, those two separate calls from two different women can be combined to establish a pattern of harassment. The escalation. If you have any prior record, that pattern, allows them to skip the warnings and go straight to a felony in South Carolina. Harassment first degree specifically includes surveillance, or watching, a person at their home, work, or school. Stalking or harassment charge. While H. 3055 is focused on creepers and stalkers, its broad language could technically be turned against aggressive salespeople. Here is the breakdown of how the law handles aggressive selling versus criminal harassment. Stalking versus voyeurism. If the looking or creeping involves sexual intent, the police often charge a different crime entirely. Voyeurism. Peeping Tom. This is an offense that requires sex offender registration in South Carolina. H. 3055 stalking. This is seen as a crime against the person. While it's a serious felony, it's treated more like an assault or a threat than a sex crime. The argument, they must show good cause. This usually means providing evidence that the harassment or stalking was sexually motivated or had a sexual component, e.g., the looking or creeping was done to satisfy a sexual urge. Judge's decision. Under SC law, the presiding judge has the discretionary power to order registration as a condition of sentencing.